Divorce is never easy, but understanding the process can help reduce your anxiety and make it more manageable. Hello, I'm Bobby Del Barina, the founder and chief legal strategist at the Barina Law Group. And today we're going to talk about a quick overview of the Texas divorce process so that you can become more familiar with it and understand how it moves through the different stages. Now, the first stage is basically what are the grounds for divorce? And in our strategy sessions, when we meet a new potential client, we go through the grounds of divorce. And there are many grounds for divorce. Some of them are fault-based, which means you have to prove them. But Texas is also a no-fault divorce state. So you look and speak and think about it, speak with your attorney and determine which ground of divorce you're going to follow. And then you look at taking those grounds of divorce and you file the petition. Now, once you file the petition with the local courthouse, you have to get that into the hands of your spouse. And that's usually done by a process server, an independent process server, who will take the allegations to let the other party know that, one, they're getting divorced and what the reasons are. And they will put that in the person's hands, and then they will fill out an affidavit saying they did this, and they'll file it back with the courthouse in that very same cause number, so a judge later will know this person's aware of the divorce. Now, the next thing that generally happens is there's some sort of response from the spouse, either a phone call to the new client, or hire a lawyer, file an answer, or file an answer on their own. So there is that response, and that response is critical because that starts additional time frames about when discovery can be done, when a final hearing can be set, things of that nature. After that, you're usually, if you're in the same household or there's community property that needs to be paid for the interim of the divorce, where somebody has to have temporary control over that, there's a temporary hearing. And those temporary orders affecting property will say who has management, who makes the payments, when these payments are to be made to preserve the community property estate. There's also the issue of children, and that's really the greater issue. Along with the issue of children, what will happen is the temporary hearing will decide on a temporary basis which parent has the right to decide where the children live. With that will come a child support obligation and a medical support obligation. And so it's very important to prepare for the temporary hearing. It usually comes very quick in the process, so to get all those things together. And then next, as the process goes, is the discovery phase, and that's where you attempt to learn more about the assets, more about the situation of yourself and the other party, financially, their background to the extent that they're a parent that can take care of the children, things of that nature that you may have to use in court down the road. Then we have the mediation, the negotiation and settlement phase, where offers may be exchanged that are generally compromised offers that still look after the best interests of the children, but say, let's finish this now rather than incur additional expenses to go to court, and let's move on with that next chapter of our lives. If that fails, then we set it for final trial. Now, for the first final trial setting, you have to give 45 days notice to all parties. Once the final trial is heard, a lot of times it's very contested. You don't do it in one day. The courts are extremely busy and can allocate a little bit of time to each case. And sometimes they may ask you to come back at least one more time to settle out the issues, get the testimony in front of them. So that's very important. And after that, we have the final decree, the written orders. And it usually takes a month to get those written, exchanged with the other attorney, the other party, and then set a court date for the judge to enter them if everybody doesn't sign them. Now, this is a quick overview of the divorce process, but if you need personalized guidance and you want to set up personalized strategy session with me or one of the attorneys in the law group, please call us at 254-699-3755. Thank you.